Hey there, gun people. We're going to talk about use of force and and use of kitty. Oh, I'm okay. Say hello to everybody out there in YouTube land. Hi, YouTube. So I told people about shooting people in the back, and cops don't have to warn you and do things. And the way cops get instruction, I'm out there painting, I'm taking a break, it's cooling off. The way cops get instruction out here, and when they're taught kind of the same case law that pretty much applies to use of force. And case law becomes case law when someone sues the government and the government loses, or the person wins, and they may not win the whole case, they just may win part of the case. So I'm going to give a couple cites here on a couple of cases that are kind of key to where cops get the authority to shoot you, to seize you under the Fourth Amendment, what's reasonable seizure, unreasonable seizure, etc. And these again, I was an instructor for firearms, for weaponless defense, so using your hands, tactics, judo throws and all that. And I was an instructor for the impact weapons, the PR-24 baton, the regular baton, nunchucks, expandable baton, etc. So each time we went to a certification course, when you would get your instructor certificate for each of those, we would go over the same case law. So when I'm teaching any of those subjects, I would use the same case law to give officers authority to justify what they're doing, why they're doing it, and what cases back them up. And by me teaching them that, I'm assuming it depends on the state. In California, it's definitely instructors are liable for what we teach. But the problem comes in is if I teach you a technique, you go out and you think you use that technique and kill somebody and go, hey, Rick taught me that. And then I come in and go, this is what I taught. This is what he used. He implied it wrong. Now the liability switches back to you. Doesn't mean you're guilty, because now they have to prove that you violated policy. The way cops use force and what authorizes us to use force is cops have a certain amount of limited immunity when we're working. We can't be sued if we're in the scope of our employment and we're within policy. Once we leave those two areas, we subject ourselves to suit. Now, even if we do get sued later, most juries are not willing to blame a cop or convict a cop unless it's really egregious. And they tell cops this in the academy. I used to teach at the police academy, and I always hear the instructors telling me, you go out there and do something wrong, you little young noob, green behind the ear cadet, and you're going to lose your house. And I used to laugh. And in the history of law enforcement, I've never known a cop to lose his house. Okay? They always talk like you're going to lose it to kind of put that fear in you. But in reality, hell, those 3 New York cops that shoved a broomstick up a guy's butt several years ago, they didn't lose their house. I don't even know if they went to jail. So it's very, very difficult to hold cops accountable. Now, whether that's good or bad, I'm not saying. I mean, in some ways it's bad, in some ways it's good. When you start arresting cops like they did in Baltimore, you make cops gun shy and they get no protection. Attorneys and DAs get protection. Judges get protection. Cops have to get some protection, or they're not going to go out there and risk their life making split-second decisions that could cost them their life, worrying about, am I going to go to jail? And that's what happened in Baltimore. The pendulum swung so far, and all law and legal decisions we're going to talk about here is like a pendulum that swings. And sometimes it goes toward the courts, use of force, government, and then when it gets too far, it swings back. And people rebel, fight, sue, get pissed off, and the law changes. So what happened in Baltimore, they charged those 6 cops with murder, and all the cops went, I ain't touching nobody, I ain't doing shit. And crime went through the roof. So in order to build trust that you're going to protect the cops, in order to go out and do this thankless job that you're going to get dogged on by the media, your own administration, policy, courts, judges, DAs, defense attorneys, in order to put up with all that BS, you have to give them a certain amount of protection or they're not going to do it. So, and I even forgot how the hell I got on that topic because I go on things. But let's get back to case law. When you're instructing, In the academy, they tell people you're going to lose your house. Cops don't normally lose their house. They normally aren't held seldom. Hell, even when somebody loses, there was a DA that got sued and lost. And when you get sued in civil court, there's damages and then there's punitive damages. And punitive damages is specifically to punish you for what you did because what you know you did was wrong and they want you to pay. Punitive damage cannot be paid by other entities. So what happens when cops get sued, the department ends up paying, which means the taxpayers pay. So when all these people celebrate, woohoo, man, we just got a cop and we won. You didn't win, you big dummies. Your taxes just went to go pay off somebody that beat somebody in court. So cops don't pay, DAs don't pay. This DA lost a case. I forgot what he did. I can't remember the case, but he sued and lost it in the court, which is very rare. Gave him an officer of the court, a lawyer, a district attorney, gave him punitive damages and says, you will pay this because we want you to pay and feel the pain because you were wrong. Guess what? The county reimbursed him in the back door. So the court got the money, he wrote him a check, the county wrote him a check so he didn't have to pay, and the system went on. So, when all these people celebrate about the government losing, the government don't lose. Somebody just posted something on Facebook about, spending all this money on these military vehicles and stuff, and it's a waste of money. And they're like, well, you know what, I hope that city goes broke for getting all that stuff they don't need. Cities don't go broke. They just raise your taxes, they raise your fines, they write more tickets, they write more parking tickets, they send the code enforcement out to do more violations about cutting your grass. They find ways to get money from you. Remember, the government doesn't produce money. They don't do anything. They take from others. So there's no reason for them not to spend because they're just going to seize more money because they have an endless supply of dumb taxpayers that they just keep taking money from. If you gave me a bank account and said, don't worry about it, it's never going to go dry because as soon as it does, we're just going to take money from someone else and put money in there, guess how frugal I would be in spending that money? I don't care, my bank account's never going dry. That's what government is. So let's get into some case law here. And I'm going to put a link in the description to this document that I use kind of like as my training notes and kind of like what I'm reading here. And it's a Word document, so you can download it and kind of review it yourself. Then if you want to look up the cases and get into specifics, some of these cases are pretty interesting because it goes into how the court comes to these conclusions, what the judges are thinking and why, and etc. And when you understand that, it helps you apply force actions. And these use of force, if you understand these, you're going to understand on what standard you're going to be held, a lower standard, not as high as a cop, but the same reasonableness. The more cases you read about use of force, cops, shooting, killing, Fourth Amendment, seizures, taking a life, all those things become reasonable. And how the court sees and views reasonableness and how they reach that conclusion on what's reasonable and what isn't. So, the first case was back in 1985, which was a really key case in any use of force case. And it's called Tennessee versus Garner, and it's from 1985. And basically, this was a Memphis police officer. He shot somebody who was running, and I think it was a kid. The officer used deadly force. Reasonably sure suspect was unarmed. He thought the kid was 17 or 18 with slight build. The Tennessee statute, unconstitutional, so far authorizes use of deadly force. And he shot this guy for a burglary. He was burglarizing a house. When the cops showed up, he ran off. And he shot him in the back. And if you remember in the old movie, It's a Wonderful Life, the guy punches the cop pulls out his gun and shoots right in the middle of town, and he shoots the guy. That was okay back then. Because you just didn't do that to law enforcement. There was less law enforcement. There was smaller government. When smaller government, they have to give them a little bit more protection, more ability to defend themselves, so they give them more power. As government grows and huge, they still keep the power. Government never gives back power, but they modify it a little bit and kind of say these are the rules, and we got to keep the sheep happy, so we can't tell them you can do anything. So Tennessee versus Garner, guy breaks in the house, runs over the fence, cop shoots in the back, says, "Halt, stop or I'll shoot." The guy doesn't stop, he shoots in the back. Legal. They sued. They won, and it made it a large case. And from out of Tennessee versus Garner, what happened was, when a suspect poses no immediate threat to the officer and no threat to others, the harm resulting from failing to apprehend him does not justify the use of deadly force. And that comes from Tennessee versus Garner. So that was the policy on Lisa 4. Officers not required to give verbal warnings. It's recommended, but it's not required, especially if it endangers officers or bystanders. So that case kind of set the stage for how it changed the use of force. Now you can no longer shoot a fleeing felon. So you have people out there running around now, oh, you can't shoot a fleeing felon. Go read Tennessee v. Garner. Yeah, you can't shoot just a fleeing felon. But if he's a danger to you or others, or he's demonstrated that danger, you can absolutely shoot him. It did not say you can't shoot for a fleeing felon. It says you can't shoot if it's not dangerous enough to where you can't justify or articulate he's a threat to others. So that was a really key case. Tennessee v. Garner is the one that most cops cite, most DAs cite, most use of force cases somehow get Tennessee v. Garner gets pulled in. There was a Franck v. Meager in 1987, and this is where an officer used a PR-24 on a DUI suspect, and they claimed it was too much. And he did techniques that he wasn't trained in. So this case law said, if you provide the tool, you must provide the training. And that where it comes into vicarious liability. If I give you a baton, I have to show you how to use it. I have to provide training on no-hit targets. Okay, targets on a body you can hit with a baton, but there's some no-hit areas that you do not hit. You don't hit in the throat, you don't hit in the groin, you don't hit in the head. Those are the three main areas that you don't want to hit somebody. Why? And they got to, there's something about the kidneys. You don't want to hit the kidneys, but sometimes that's the only thing that's available because it's a large area. But, so cops aren't allowed to hit in the head, throat, or groin. Well, sometimes you do get hit in the head, throat, or groin, and that's because in the standard thing for cops to use, and it's normally true, but if a cop wants to lie, he can't, is say that the person's dodging, resisting, ducking, and dodging caused me to miss my target area. I was not aiming for the throat, head, or groin. However, when I hit him in the head, he was ducking, dodging, charging me. I was going for one of the other strike zones, but because he was charging me, he got hit in the head. And normally it's upheld, no problem. If you're resisting, you get hit in the head, you shouldn't have been resisting. Now, if you're just sitting down on the ground doing a peaceful protest, cop comes up and bings you in the head, obviously, he's got some explaining and it ain't going to work. So that came out to where you provide the tool. If you remember the case up in Davis where the cop sprayed all the protesters, if you go on anywhere, you can see a picture of this cop. He was a lieutenant. He's a pretty good guy, although he made a mistake there. When he sprayed everybody with that pepper spray, he was legal in doing that, and he was justified in doing that. However, the pepper spray he used was a large new canister that they had just bought for the PD, and nobody was trained and it wasn't authorized to be used. So when he went and grabbed that because there were so many people and then he used it, the department was able to say, hey, you used something that we didn't issue you, we didn't train you on, therefore our liability switches you. Now he never got sued, he never got anything, because they rarely go after cops in these civil cases, because cops usually ain't got no damn money. They want deep pockets. So they go after the city, etc. They go into vicarious liability. They want to sue the person that trained it. And who trained that officer? What agency trained him? What college trained him? Who trained him? Let's go after him because he's got insurance. Did the department fail you to train? And we'll get into a couple of those cases here. Beluw, B-E-L-U-W versus R-U-P-P-O-R-T. Report. I call it report, but I don't know if it's pronounced that way. 1987. If a shooting is justified, there's no reason for an officer to justify a lower force. And what happened in this case, and I didn't put a note here on how the case was dissolved, but basically what it said is if I'm allowed to shoot you, there's no reason I have to hit you with my baton first. I don't have to do any lower force, because once I'm authorized to shoot, I can shoot. I don't have to justify. So if you pull a knife on me, I'm authorized to shoot you. A lot of people say, well, why didn't you tase him? Why didn't you pepper spray him? Why didn't you run away? This case right here says, once a cop is authorized deadly force, there's no reason or justification for him to do anything less. He's authorized to shoot you. If he shoots you, it's a done deal. If he was authorized, it's a done deal. He does not have to go back and justify why he didn't do that, why he should have done that, blah, blah, blah. So that's an important case for use of force, because they're always going to go to that. Why did you do this when you could have done that, etc.? In this case, protects you from that. Ford versus Childress, 1988 case, a fleeing felon shot rule. The suspect robbed a bank and the officer shot him in the back as he ran out the store. No problem. Why? Because they cited Tennessee versus Garner. He was a fleeing suspect that was just robbing a bank that presented a threat. Now, the officer didn't know that he said he had a gun when he didn't, and he wasn't armed when he shot him in the back. Okay? So, and the other issue in that case, and there's another case that provides that, officers can react on what they know at the time. They don't have to go back and second guess and well, shoulda, woulda, coulda. You can only evaluate an officer's decision and what he known at the time. The flip side of that is you always see on the news when somebody does something that's really bad, they post that the suspect had several prior arrests and that the suspect did this and the suspect was a gang member. Unless the officer knew that when he used the force, doesn't matter. Doesn't matter what the guy, if he was a mass murderer. If Charles Manson escaped from it, and I don't know who Charles Manson is, and I end up shooting him, and it's not justified to shoot him, I later find out he's an escaped prisoner, he's Charles Manson, it's a no good shoot, because I didn't know it at the time. I have to justify, you as a citizen, has to justify your use of force at the time you use it on what's known to you at the time. Now, things like high crime area, robbery just occurred in the area, matched the description of a suspect who was wanted for armed robbery, things like that, all officers know because they're briefed at briefing, they hear dispatches, they hear bolos be on the lookout, come across the radio. So all of those things can be used, but you have to know it at the time. In this one, they also brought up that the officer warned him, but the suspect said he did not hear the warning. Doesn't matter. If you warn, you did more above, because there's no requirement for warning. But if you warn, the suspect does not have to hear the warning. Now, where there's an issue in that is a knock-in notice when you do search warrants. When I knock on the door and say, police search warrant, demand entry, I have to say it loud enough so somebody in the house could reasonably hear it. And I've seen cops knock on the door and go, police search warrant, because they want to kick the door. Police search warrant. Now they'll say they don't want them to hear because we'd rather kick the door so they don't destroy evidence. But technically, we're supposed to announce, then if we hear footsteps or think they're destroying, then we kick the door. And then you can also go for a no-knock warrant. So what I used to do, and what good cops used to do, is we would put somebody at the rear of the house. And when we would knock and notice on the front door, police search warrant, demand entry! Police arrest warrant, demand entry! When we yelled, the person at the back would acknowledge and give us a statement that we heard the knock and notice. So anybody in the house would have reasonably heard it if a guy all the way on the other side of the house would have heard it. Now, is that required? No. Is it smart so a defense attorney can't come back later and say, my clients didn't hear the knock and notice, therefore you shouldn't have, should have, would have, could have, didn't, whatever. We can say, hey, we'll put a guy at the back. So, Forrester versus City of San Diego. This is where some protesters were arrested and the chief did not want his officers to pick the protesters up and carry them off, which would have been nicer than doing pain compliance move. Putting a baton on the alder nerve, doing a knuckle to the ear, doing knuckles underneath the throat. Any of those pain compliance that you see and the person's putting a finger under the nose, and you make a person scream, it hurts. That's why it's called pain compliance. You do pain so they comply. Okay? So the officers did pain compliance and the protesters sued, they used force. All they had to do was pick them up and they would have walked. Well, the chief said, I don't want my guys picking them up. I got female officers, they can't pick them up. I don't want injuries. I don't want cops going out on back injuries. And I don't want you picking them up. Use pain compliance. In this case, Forrester versus San Diego said, hey, officers are not required to pick you up and carry you. If the force is authorized, you fail to comply, you're given an order, and the officers can use pain compliance, then they don't have to use anything else. They can use pain compliance. There's no requirement for them to use the carry and grab. So that was the case for that. Graham versus Connor is another big case. This is in 1989. Hang on, my thing just kind of jumped on me here. Cops stop a suspect for leaving a store too fast. What happened was these two guys went to a store. One guy was having a diabetic thing, so this guy goes, hey man, I'm going to run to the store, and I'm going to grab you some orange juice. So the guy leaves his buddy in the car, goes in the store. When he walks in, there's a bunch of people, and there's some cops there. He's like, shit, I don't want to put up with this. My buddy's sick in the car, and he leaves. Well, the way he left in such a hurry, the cops went, that was kind of odd. He showed up, saw the cops, he got the hell out of here. I don't know if there was a robbery or what was going on in the store before, but the cops went, this is odd, I want to know who that guy is. Fairly reasonable. They don't know that there's a diabetic in the car. He jumps the car, drives off, the cops pull him over, stop him, they handcuff him, they detain him, they sue him for unlawful seizure, saying they didn't do anything wrong. This case, Graham versus Connor, officer's decision is based on facts and circumstances known to him or her, and it also goes to the scope and level of intrusion. The scope and level of intrusion is how much did you intrude? Did I tie you up, hog tie you, drag you in a back car, put you in a patio wagon for 3 hours till they took you to jail, hold you overnight, and then a few hours later I went there and checked something and went, okay, I'll let you go, and then let you go. That's a bigger scope of intrusion than me stopping you, handcuffing you, saying, hold on, I want to investigate what's going on, then I let you go on scene. That's a low-level intrusion. It's more than I would like government to do, but it's lower level than what a rebel. So the court ruled, hey, and the other big thing about Graham versus Connor is it says it does not care what the motive, what was it? The underlining intent or motivation of the officer. Because defense attorneys were arguing that, hey, these officers just wanted to check my guys for drugs, and they just wanted to find out if my guy was on probation. And they stopped him for other reasons, other than just because he left the store fast. The court said, we don't care. We don't care what the underlining is. If he's authorized to do it, if there's reasonable suspicion, and he saw it was reasonable, and that sounds reasonable to us, and they stopped, and the scope and level of intrusion is low, then they're authorized to do it. Doesn't matter what their intent is. And we get that all the time. I see a guy, he's got tattoos on his neck, I think he's on parole probation. Alright, I say I want to stop him, so I go, hey, you know what, he didn't have a license plate light. Light's supposed to be lit up, I can't read his license plate, I'm going to pull him over. Pulled you over a license plate, you got a driver's license, I check him, see he's on parole probation, let him go. See, a lot of people go, oh man, you can't do that, you just stop. The court says you can't, it doesn't matter what. If I'm authorized to stop you, then I can stop you. Doesn't matter what my intent is. A lot of people aren't going to agree with that, and they're going to be pissed off and think I'm a bootleg, whatever. But hey man, I'm just giving you case law, okay? Cops have to apply with the law. If you understand the law, then you can either defend yourself, protect yourself, or use the law to your advantage. Reed versus Hoy, 1990. He was dispatched to a resident on disturbance. I think this was the domestic violence. Hang on. Possible Hoy. Oh yeah, Mrs. Reed. So basically, cop shows up. It was supposed to be domestic violence. Confronts a suspect in the front of the yard. The guy goes, hey man, I want you off my property. Cop goes, I'm not leaving. He goes, I'm here for domestic disturbance. Where's your wife? Man, I told you, get off my property. I don't want you here. Cop says, I'm not leaving. Everybody's like, hey man, private property. Cops are there. If he don't want you there, he should be able to leave. This came up as a question on one of my other videos. Cop said, I ain't leaving. Guy gets up, picks up a bamboo stick, comes at the officer. Officer draws his gun, says, dude, I'm going to shoot your ass, I ain't leaving. Guy, I think, charged him. I don't remember if he ended up shooting this guy or not. I don't think he does. He drew a service revolver, pointed at Reed, again requested Reed. Hoy testified Reed continued to advance, grabbing with both hands, raising in a threatening mode. Hoy then shot Reed in the chest. Okay, everybody's going to be cracking up because I'm laughing. He was laughing because the guy got shot. Hey, you know what? You come at me with a stick and I tell you to stop, you're going to get shot. Tough luck. Okay? Play stupid games, win stupid prizes. So, if a guy comes, and what this case ruling came out is, officers have no duty to retreat. We do not have to retreat if we're where we're at, doing the job we're doing, and we're authorized to be there. This was a crime. We are not going to leave till we determine that the woman isn't tied up, being held hostage, bleeding, stabbed, dead in a bedroom. We get called for domestic violence. We're going to find out if she's okay, and we're not leaving till then. So this guy was like, my property, get off. He did. He charged cop. He got shot in the chest, and they sued and lost. I think I'm going over time here, so I better speed it up here. Sager versus Woodland Park put liability from the officer to instructor. And basically that provided the officer technique within guidelines that it was taught. And there's three kinds of liability when you're teaching. There's personal liability, there's vicarious, which is the instructor, and then there's respondent superior liability, and that's the department, supervisors, etc. There's been a lot of cases that were ruled against PDs because supervisors failed to protect. LA, they had that squad out there doing all that BS, I forgot the name of it, Rampart, where they were doing something. But because it was a standard procedure and administration knew what was going on, they never corrected it. And when they interviewed all the officers says, hey, that's SOP, that's how we do stuff. It was normal. And all the supervisors said, hey, that's the way we do it. That's normal. They were held in this case because it's like, hey, hell no. You cannot unsupervise people and allow them to do the wrong thing, because then it becomes accepted. It becomes normal, and it shouldn't be. So then the liability switches to the supervisor independent. Whitney versus Harris is a lack of training called deliberate indifference. And deliberate indifference is, if, let's say I'm an instructor, and you come to my baton class, and like, okay, this is a baton, it's 36 inches of wood, it weighs so many ounces, and you kind of swing it like this, and go ahead and hit people here, but don't hit them in the head. That's pretty much the class, man. I got a date, I'm out of here. Anybody got any questions? Cool, and we leave. Deliberate indifference is, I deliberately sent these guys out with a tool without training them, and it was flagrant, it was unnecessary. That would be one case of deliberate indifference. But deliberate indifference as a whole is just like, you look the other way. You don't really care. You don't take it seriously. You don't, ongoing, required training, proficiency training. There's certain things that cops have to have continued training, like evasive driving. You have to go on a skid course once a year. You have to do these things. So if I go out here and kill somebody and I'm chasing somebody and I haven't had driver's training in 3 years, that's going to be deliberate indifference on the department for failure to train. And all these come into the same area. And then there was Bordolero and Melito expanded deliberate indifference to training retention. This came into where the agencies were hiring their friends, buddies, neighbors, etc., even though they had distributed traits that they wouldn't be a good officer, etc. Then they went out there, they were too aggressive, they liked to hurt animals, whatever, they hired them, then they went out there and did something wrong. That would be a deliberate indifference of the department to ignore reasonable facts that would lead a person to believe this person shouldn't be out here enforcing the laws of carrying a gun. Okay? And then retention and supervision goes back to retention is, I keep somebody on the department after they've had 14 IAs for use of force, or 14 IAs for grabbing a woman's titty when he's searching them, or 14 IAs for whatever, and we continue to keep this person. You don't get rid of him because he knows the chief or his buddies, whatever. They had a guy in my department that was like that, this lieutenant that should have been gone a long time ago. He's in one of my cop stories. Let's see what the other one. Officer shot. This is a good one. Elliott and Levette out of the 4th Circuit in 1996. Officers pulled their gun and shot a guy that was handcuffed 22 times in the back of a patrol car. And everybody was outraged and said, that's unlawful, that's unreasonable, that's way excessive. Guess what? Court ruled no, it wasn't. Because what happened is they arrested the guy for DUI, handcuffed, put him in a car, they did a shitty search, their fault. While the guy was in the car, he reached in, grabbed the gun, and he pointed at him from the car. Well, he was drunk. Now, was he going to shoot? I don't know. He didn't have a chance because 2 cops pulled their gun and shot him 22 times and killed him. Well, the bleeding heart mom who raised the kid to be an alcoholic, whatever he was, came and sued him and said, oh, you killed my son. He was going to college. He was a good kid. He was just getting his life together. Shut up. So she sued. Of course, she didn't sue. Some lawyer took a case because they thought they'd get money. And they lost because the court, this is where the court really ruled that. They ruled, one, an officer doesn't have to wait for you to shoot him to figure out what your intent is. If you point a gun at an officer, you can shoot him. You don't have to wait. It's not reasonable to have officers wait to get shot because they may not be able to return fire if they wait. If you point a gun and the cops are allowed to shoot, then they can shoot. As for the 22 rounds, the court said, not only is that not excessive, but that shows the fear of the officers that they fired so many rounds in a short amount of time, so rapidly, that shows the level of their fear that they were afraid they were going to get shot. That even justifies more their use of force because their level of fear was so high. So, now, could you do that if you're sitting back with your feet crossed and I'm sitting here going, hey dude, drop the gun, bang, and you fall and I go bang, bang, and bang, let me reload, bang. Would that work? No, but in this situation, in this case, it happened very rapidly. The guy pointed a gun, the officers drew their gun, emptied their guns on him, and he died. I guess you can go over these in the must plan, handcuffed after it was shot, as long as it's within policy. Hog tie suspect safe down. You don't want to do that. You don't want to hog tie a guy face down because, especially if they're big, it can stop them from breathing. So this case right here said you don't want to do that. Kenner versus Gall out of Ohio in 1996 and 97. Off-duty officer killed DUI guy. Supposedly he was out of policy for some reason. Court said it doesn't matter. This is Soller versus Moore. Doesn't matter. As long as he was authorized and it was reasonable force, the officer's good to go. Doesn't matter what policy is when he's off duty. So the officer was found good on that. Cox versus Treadway, heat of the battle instruction. Fuller versus Vine, Ninth Circuit. Pointing a gun at somebody is not a seizure. They were saying when you point a gun, you get somebody to lay on the ground, etc., you're seizing him at that point. Court said that's not a seizure. I kind of think it is because you're taking away the ability. But technically, just because I point a gun at you, you can run, and I can't shoot you. I could shoot you, so it's up to you. You can run. Since you can run, it's not a seizure. That's the way the court ruled. And then the other things, for physical skills and structure points, I always go over effects of stress, decreased cognitive function. I don't teach fine motor skills. I teach large because in stress it goes. The highest litigation for law enforcement is always in use of force and driving. Those are the two areas that cops are always in trouble for. And when you're doing policy, get rid of necessary. A lot of cops used to say necessary force or do what's necessary. And they got away from that. And everybody wants to go reasonable now. The courts and everybody, reasonableness, what's reasonable for a person in the same set of circumstances. All right? And that there, hope that helps.